the goal tonight is at the end of our discussion here is for all of you to have a better idea of what judges are going to be looking for in the oral rounds and in the written memorials. And to understand what the judges are looking for, we really do have to have a basic framework of how argumentation, in particular, legal argumentation, actually works. And so one of the things that I've done for a while for both lawyers in general, for associates and interns at my firm, and for Jessupers, have been talking about and working on presenting what is argumentation, how do the parts of an argument work, and fundamentally, how do those things come together? Because ultimately what the judges are looking for in a competition like this, or for the rest of your legal careers, what people are looking for is for you to make effective arguments that make sense and that have all the constituent parts of an argument. So I always like to kind of start things off with the idea that argumentation isn't about contradiction. It's not just saying no. It's advancing a claim, an affirmative statement that you want the judge, your audience, your teacher, your boss to agree with you that this is the way that the world is. And simply saying no, where it isn't, that isn't true, isn't sufficient to be an argument. So when we think about arguments, the European model of that is to look at it in kind of three different ways. We have the mathematical argument, 2 plus 2 equals 4. We have a more rhetorical argument. This is about persuasion. This is where you get into the Aristotelian ideas of like ethos, logos, and pathos, like an emotional appeal, which isn't really applicable here. We're really looking at that kind of logical persuasion. And then when we get into dialectics, we're talking about a dialogue and a development of an idea through discussion. Ultimately, what argumentation about is taking a position and supporting that position with evidence that convinces your audience, the judge, your boss, your friend, your parent, your spouse, to accept your position to be the correct position. If we really want to break down argumentation, we have to do a lot of math. But we have all chosen to go into the field of law because we are bad at math. And therefore, we are not going to be dealing with any of that tonight. Instead, we're going to talk about, where these concepts come from. One of the components of rhetoric is this idea of ethos, the authority of the speaker, that the person saying it, that it must be true because of the position and the authority of the speaker. And in your real lives, everyone has individual credibility about who you are with your audience. In this format, I get to take advantage of some of that because I have some credibility that I actually might know what I'm talking about because I've been invited to talk about these things to this audience. In the Jessup competition, all of the agents are kind of in the same position, so you don't really gain or lose anything on this. That said, some components in the oral argument, style in particular, do try to pick up some aspects of this idea of credibility, speaker's authority, that the people who are able to engage in the oral argument, that are responsive to the questions, they seem more credible because they seem more engaged in the argument. And so you can pick up some aspects there. On the other hand, pathos, the idea of an emotional appeal, the idea that, the sob story, the the sad music of getting emotion into a movie doesn't really play a part in the Jessup competition or generally in a lot of the legal work that I do to financial work, commercial disputes. The fact that one bank lost money is not going to get an emotional reaction from folks. When we look at more human related legal work, in the United States, we would typically think of that as like plaintiff's trial work, where the old Matlock trying to make you feel sympathetic for someone. Pathos, this kind of emotional appeal comes into play, but it has really limited application in the Jessup and in most legal work, in my opinion. The logic, though, is really where the core of the Jessup work is, that your arguments make sense, that they are rational, they are logical, and that the building blocks that you are putting together support your position and convince the judges in the competition that your position is legally correct, and persuades them through reasoning. When we build out an argument, we're trying to put all of those pieces together. And there's a lot of different ways to structure or to create a map of your argument, starting with the idea of the claim or the contention that something should be done, and to figure out how all of these pieces fit together. And in particular, I like using a model from a gentleman named Stephen Tolman, and we'll talk about him for a bit. But to kind of get everyone on the same page with the terminology of argumentation, the main point is the idea of the claim. This is the conclusion that you are trying to persuade your listener, your audience, to accept as true. And in the example in kind of this material is the idea of I am a British citizen. That is the contention that the speaker wishes to convince the audience of. And the grounds and the data to support that is the facts, the factual basis that we are using to build that contention. We haven't gotten into the legal rationalization yet. This is just the facts. These are the facts from the compromise. That, in order to support the claim that a person is a British citizen, you could say that the grounds that support that is that they were born in Bermuda. Then you need to connect those facts to the claim. And this is called the warrant. This is the legal connection between the factual basis and the claim that you are making. And here would be a legal code or a legal conclusion that says that any person that is born in Bermuda will be a British citizen. So now we've connected the original fact, born in Bermuda, with the claim, British citizen. Oh, persons born in Bermuda will be British citizens. The backing is the credentials, the citation, the source of law, the answer to the question that you will always hear from judges when you make a legal warrant type argument, says who. Well, in this case, says who is the British Nationality Act of 1981 that says, and consistent with language from 1981, a man born in Bermuda will legally be a British citizen. Typical sexism from 4 decades ago. And then, whenever we make arguments, we always try to make these giant legal arguments, but the world is a complicated place, the law is a complicated creature, and there's always exceptions and nuance. And so there may be exceptions to that general warrant, legal linkage that you're trying to argue. As applicable to our kind of example here is that someone who's betrayed their country and been denationalized is not going to be recognized as a citizen. So there are going to be exceptions to our general legal rule. But if in our example, our person we're seeking to have established as a British citizen has not betrayed their country and become a spy, well, this exception doesn't apply. And when it comes to argument, making sophisticated arguments, recognizing the exceptions and how they don't apply to your situation makes it more effective when you're talking about the makes it more effective. Oh, I lost my chat. I'm sorry. Oh, there it is. Sorry. Making the exceptions, understanding the nuance, and making narrow statements of law or acknowledging exceptions and how they don't apply makes your argument better, because it's less grounds for someone to say the exception swallows your example. The last part of that is the idea of qualification. And this is a degree of certainty, probability. In most cases, when we're applying, an idea from the law, there are some gray areas. There are some areas around the edges, and that by qualifying your statement, instead of speaking in absolute terms that something, is or is not, using these kind of terms of qualification helps introduce nuance to the argument. And so this is the idea of saying, a person is definitely a British citizen versus I am presumably a British citizen. And this helps flavor your argument of how strong these relationships are. And that in some way does go to your credibility. All of this comes from Stephen Tolman, the Tolman model. 3 books on the argument, the uses of argument from the 58, a book he wrote on the debate format in 63, which I think is probably less helpful, and then the Introduction to Reasoning that really moves into a rhetorical dialectic discussion of these concepts. The uses of argument is really focused on the idea of legal scholarship and making legal arguments, and it is a book that is still really well regarded. In addition to all of the batch material that you're already reading and all of your other coursework, I would recommend paging through the uses of argument or a similar text, or supplemental materials that are written about what Tolman does to try to better understand these concepts. So we kind of put these things together, that you want to have your claim is the thing you ultimately want to get to. The grounds are the facts that you start with from the compromise, and the warrant is how you connect those two things together. We start adding in all of those other pieces, that the grounds lead to the claim, the warrant supports it, the backing is the source of that warrant, and then the rebuttal and the qualifier are limitations on the scope and the breadth of that line that you're generating. Another way of kind of structuring it, there's a lot of different ways to visualize and to put together these pieces, with the idea that you start to see the relationships to them, that the ground and the claim are connected, and then the rebuttal and the qualifier are modifying that claim aspect of it, rather than the relationship between the ground and the claim. It's the scope of the claim, how big or small the grounds on which the claim are. So where do we attack an argument? Because you've now spent all of this time building your argument. But if you're on the opposing side, you need to listen to and process and address your opposing party's arguments. Or if you're the first speakers in the round, you need to anticipate the opposition arguments and figure out how they are coming together and where you can start pulling them together. when we talk about the grounds or the facts being wrong or incorrect, this is incredibly rare. The facts are written in a way that they are, in a lot of ways, they are what they are. They're never going to give you a win on the facts. And so arguing about what the facts are or what the facts aren't is rarely effective. On the other hand, if the opposing argument is that the sky is red, and that's demonstrably false from the compromise, that can be useful to attack if that grounds is really critical to the opposing arguments. However, more appropriate is to focus on the idea of the rebuttal, the cases in which their claim is not true. And this may well be your own argument in opposition with a separate grounds, a separate warrant, separate backing, and that your rebuttal claim covers the ultimate grounds and the ultimate conclusion that should be reached by the court. The last concept that's particularly useful is the idea of what I call warrant theft, that the opposing party has spent all of this time developing the context of the legal relationship, how a particular aspect of the law works. For example, the particular rules on, from a couple of years ago, treatment of prisoners of war under the Geneva Conventions. Your opponent spends several, moments building out the argument, laying out what it is, and you can then kind of steal that, say, yeah, all of that is true. And we'll add a little nuance to it that says, in this circumstance, this doesn't apply. For example, they aren't prisoners of war. Or on the other hand, that they are, and under these circumstances, they're entitled to these additional protections that obviously weren't met, and therefore your side prevails. Using your opponent's, your opposition's components of these arguments and integrating them into your rebuttal of their arguments is really effective, because it shows that we all agree it's really the application, and that saves you time. And in a Jessup round, particularly an oral round, your time is one of your resources that you have to manage. It's also true in the memorials, but you can't rely on someone else's memorial. You can't say, oh, Columbia University wrote a great memorial on this issue, and we're just going to take their argument. Oh, we're going to take Singapore's argument because we know what they're going to say. Unfortunately, you can't do that in the memorials. This is really an oral round tactic. The other thing to think about is how much of your argument is based on the same underpinning warrant or the same underpinning relationship. Because if your argument all relies, if you make 4 big arguments and they all rely on one legal proposition, one warrant connecting multiple points of data through that warrant to multiple claims, you're setting up that warrant as a key aspect of your argument. And as a result, a good opposing team is going to say, hey, their argument rests entirely on this one conclusion. And that allows them to focus their time on attacking one aspect of your argument. And to the extent that they're successful, they're able to take out 4 of your claims. Now, can you build separate and independent legal rationales for each and every claim? No, it's incredibly inefficient, and you may not have time to do it. So you have to balance the risks and the rewards between time management and efficiency and only talking about one aspect of the law. When you are questioned about your arguments, the nature of the question is going to help you understand which part of your argument that the judge is inquiring about or challenging or pushing back on it. When one of the judges asks, hey, what facts, what part of the compromise supports your claim? What the judge is asking about is your grounds, your data. What information, what facts from the compromise are you discussing? And so your response can focus on those facts. Separately, when the judge asks, what law is that, or how does that interact with another piece of law, what they're inquiring about is the legal relationship, the warrant. And more specifically, when the judge says, says who, according to whom, again, that really is going into that backing aspect, the citation aspect. Where does that warrant come from? And to explain that. One of the most common areas of frustration I found on benches is when a judge asks about the law. We're inquiring about your warrant or the backing to an argument, and the response from the agent is talking about the facts of the compromise. And judges are trying to be polite. We should be letting you answer the question the way you want, but ultimately what will happen is if you're not addressing the right part of the question, I ask the question, what law supports that claim, and you respond with, citations and explanation of the facts in the compromise, my question hasn't been answered. And in a best case scenario, I'm going to ask the question again to give you a chance to explain the law that I'm trying to get from an agent. But even in that best case scenario, you've burned 20, 30, 45 seconds of your limited resource of time. And, in a 20 to 22 minute presentation, if you're answering the wrong thing for 30 seconds, you've lost 1% to 2% of your entire argument time to doing that. A handful of questions like that, you can lose 10% of your time by accident. The other kind of question you'll get, particularly when it relates to the law, is when a judge sets up a different legal regime and says, well, what about this law and how does that apply? This is really the rebuttal. This is the what about this opposing argument and how does that affect your warrant? How does that affect the scope of your claim? And so here you want to kind of address those qualification issues to limit your claim so the rebuttal is not within the scope of your claim, or directly address the rebuttal. Same thing goes to the question of, is your claim always true? Are there exceptions? Are there limitations? Is every person born in Bermuda a British citizen? Obviously, the answer to that is no. There are some people who have been denaturalized. There are some people that are born in Bermuda that are that have other nationalities, that they were in Bermuda temporarily and they don't qualify for British citizenship. So these are those qualifications and rebuttals. You can avoid some of these questions by being more precise when you make your claims. On the rebuttal side, you want to be looking at identifying those combinations that you can make a single claim to undermine multiple arguments. And when people aren't putting all of these pieces together, you can start talking about, hey, those grounds do not lead to that claim. This warrant doesn't exist, this legal rationale doesn't exist, or this legal rationale is so qualified it doesn't apply, to kind of break the linkages of this structural argument. So when we talk about the Tolman model, we always have to qualify the claim that I am making, that the Tolman model is a good way to make arguments. It is a formal way to evaluate arguments and to think about argumentation. But rote application in your speaking and in your argument is not going to be particularly effective. First is that this is a very academic model, and that not all judges in this competition are formally trained in argumentation. A lot of them are lawyers who have been their entire lives arguing because they're good at it because of the way they, have a life experience. Was never intuitively good at argument. I got good at making arguments through academic training, debate programs, moot court programs, and studying argumentation to understand what's effective and what's not. Being good at argumentation is not an inherent skill. It is just like anything else. Now, we all know people that are really good at a sport. They're really good at football. They can always kick a goal because they are innately athletic and talented, and those people are annoying for the rest of us who have no such athletic ability that have to work at it. It's frustrating, but the people that work at it get better at it. The other big limitation in that is it is really based on a single claim approach, that each of these arguments is built as a separate independent piece. The world is more complicated than that. Argumentation is more complicated than this. Rote application of this in a linear, dry format is not going to incorporate multiple dimensions to your argument. It's not going to automatically incorporate complex concepts. But these ideas I think are worth thinking about in how to put together your argument, understanding the components of your argument, and so that you can use those components more effectively, particularly in oral rounds on the fly, where you understand where the judges are going, you understand the weaknesses of the opposing arguments, and you understand the strengths and weaknesses of your own arguments. This slide did not do well, but the idea here is to show how more and more complex arguments start having claims as being the backing or the warrant for a new claim into another claim, and they start getting more and more complex. This diagram is an evidence and argument map from a murder trial that shows the complexity of how these things get continually bigger as you're dealing with more and more complicated situations. Trying to graph out or to compartmentalize the entirety of your argument in this model and figure out all of these little blocks is not a rational way to approach oral argument or your written materials, but the concepts are things that you should be aware of. So this is an argument that is going to be, I'm going to show how an actual argument works, particularly in the Jessup concept. The claim that I am making, the argument that I want the court to accept, is that the Israeli downing of a civilian Cessna 152, a very small plane, it's like two-seater little propeller plane, in 2001 was lawful under international law. That's a lot. That's a fairly large claim. A country shooting down a civilian light aircraft was lawful. Your gut inclination is to say, no way. So let's talk about the facts. In 2001, Cessna, this little tiny plane, you can see a picture of one on the right-hand side, took off, flew through Lebanon into Israeli military airspace, did not respond to a helicopter trying to communicate with them, and was ultimately shot down by that aircraft. The pilot was a student pilot who took off from Beirut without authorization. The aircraft was stolen, and during the process of it being stolen, it did knock an airport worker who was trying to figure out what was going on. It was intercepted by military aircraft and helicopters, and the pilot of the helicopter reported making eye contact with the pilot prior to engaging the aircraft. After about 15 minutes with the aircraft trying to intervene and intercept and to get the aircraft, the light aircraft, to change its course as it was heading towards a populated area, the helicopter was ultimately shot down by the helicopter's machine gun. And that's a photo of some of the remains of the aircraft. So, those facts connecting to my contention that that was lawful. The first piece of warrant I would offer is to say an aircraft that's been determined to be a threat, it's engaging in offensive action to which the offending country is entitled to respond with force. And the backing for that is the Geneva Convention, specifically Protocol 1, Article 52, Subpart 2. Now, I have to address the rebuttal that the Chicago Convention, which regulates air traffic, particularly civilian air traffic in the international regime, says that every state has to refrain from using weapons against civil aircraft in flight. And in the case of interception, which is what happened here, the lives of persons on board and the safety of an aircraft must not be endangered. The opposing arguments got a whole bunch of lift here. They're entitled to require the landing, not really applicable here. And then we have C, every civil aircraft shall comply with an order given within paragraph B. The interception was communication instructing for landing. So, how do we qualify that warrant and the claim to say what has to happen in the event of an interception where the offending aircraft does not respond? Well, a country whose airspace has been violated and has directed the offending aircraft to land using internationally recognized symbols, they've done that. The offending aircraft then continues to violate the airspace, and there's no excuse, no reason of why that lack of compliance that's required under international law by the civilian aircraft has occurred. Check. And third, the offended country reasonably perceives a threat from the offending aircraft, and that there is information or circumstances that there is something nefarious going on, that this aircraft is in fact a threat. And my source for that is Brian Font. I would argue he's probably not, the highly respected publicist, but his article synthesizes all of the constituent parts of this argument from other sources of international law. And if I was challenged on Mr. Font's qualifications in an oral round, I'd be expected to explain where he got these ideas from. Whoa. So that's the argument, that having complied with all of these, this particular instance was lawful. In reality, this incident happened during one of the many phases of international conflict that Israel has been engaged in, and the aircraft having left from Beirut, the country of Lebanon took no action, did not even complain at all of the incident of this, and they would be the flag state for the aircraft. And this 2001 flight is generally viewed in the literature regarding aircraft interception and shoot downs as being lawful, as being an instance where it was lawful. One of the very few instances of where this conduct was lawful, actually. So when we focus on and look to specifically the oral rounds, the first place that we should look for the oral rounds is, of course, the score sheet. Because ultimately, your jobs as agents is to figure out how many points you can drag out of the bench. And your goal is to walk out of your round with as many points as possible. So I mentioned on the prior slide that Mr. Font wasn't a highly respected publicist. There isn't a direct answer to the question of who is and who isn't. There's a body of kind of highly respected publicists in general. These are generally, the International Court of Justice jurists, Grotius, the big obvious names in international law. You'll see a number of them recognized in, ICJ decisions being cited. A lot of times in ICJ decisions gets you there. The other aspect to these highly regarded publicists that can be a source of law under the court statute is specialty qualification. Off the cuff, I can't think of any particular names, but when we look at particular conventions, they're going to have a couple of people who have spent their lives and their careers developing that area of the law. That's particularly true with things like the law of the sea. So you get that. You also have institutions that kind of get this same treatment. The ILC, for example, or for a particular convention like the special rapporteur or reporter for a convention is generally going to fall into that category of highly recognized publicists. In terms of application, where you have an argument that is heavily relying on an individual's development of the law or articulation of the law or argument for expansion of the law, you need to know their background, why they should be considered a highly respected publicist. A couple of years ago, there was a compromise that had a developing area of the law, and one of the people who wrote and who was cited in a lot of oral arguments and in a lot of memorials with the assumption that they were a highly recognized publicist. Their article was actually a doctoral work that they wrote as a student, and I believe they were a clerk with the ICJ while they were a student getting their doctoral. That understanding who your people are to qualify them as being correct solely as a result of them being a highly regarded publicist is really important. That said, just because someone has only written once in a space or is a newer voice advocating for it doesn't mean you should ignore them. They may be making very good arguments, and your reliance on the strength of their arguments shouldn't be based on their credibility, their ethos. It should be based on the components of their arguments that you can adopt and make those same arguments, attributing it to that person. We're not advocating plagiarism, but the strength of your argument is based on the sources they're using, not their name. So, oral round score sheet again. Where do your points come from? And I always like to point people to the score sheet because that's how you get the points. 30 of your 100 points are going to come from knowledge of the law. This is entirely from the warrant and the backing, the legal rationale and where that legal rationale comes from as a source of law. That by itself, 30% of the points. 25% of the points come from the questions and answers, how you answer questions. And the majority of the questions that you are going to get are going to be questions about the law. The Jessup is a law competition. So the questions are primarily going to relate to the warrant and the backing, and to a sometimes greater degree, the rebuttal of the claim based on changes in warrant and backing, and qualification of the claim based on nuances in that legal argument. At this point, I have not mentioned the compromise or the facts yet, and we're already at 55%, where at more than half of your oral score hasn't dealt with the facts at all. So, knowledge of the facts. Knowledge of the facts is 20% of the score. Knowledge of the facts is both your understanding of what the facts of the compromise are, but more importantly, why those facts are important to support the warrants that lead to the claims that you're making. It's not merely a memorization exercise of what are the facts in the compromise, but rather why are the facts in the compromise that you are talking about legally significant? Why do they matter to the determination of the issues being presented to the court? The individuals who do the best in knowledge of the facts, it's not just that they know who did what, when, or the sequence of events. Just knowing those things is average or even slightly below average because everyone has been learning the facts for the months leading up to the competition. The agents who pick up a lot of points in knowledge of the facts that get the high scores here understand and are able to articulate what the facts are, but also why those facts are legally significant. So even in knowledge of facts, why the law component still starts to shine. The bottom 25% go into style, pose, and demeanor for 15%. These are the non-logical components to your argument. Your ability to speak calmly, clearly, to be responsive, to have a good attitude, a good exchange with the bench. Generally, agents do, okay here by just being themselves. The agents that really pick up a lot of points here are the ones that maintain the formalities of the competition. And the folks that tend to do poorly here are the people who get angry, that get frustrated, and that make it personal. And then the last component, 10%, organization and time. Are you spending the right amount of times on the right amount of things? Are you getting back to your argument? Are you putting together all of these pieces in a way that makes sense, that flow from one to the next? But you'll notice those things, the further we get away from the pure law focus, the less and less points they're worth. So every judge is going to be looking for something different. And obviously, I can't speak for the 600, I think Michael just said about 800 odd people that are around the world judging these Jessup rounds. I can only speak for myself and the rounds that I've judged. I've judged a lot of rounds. I was texting earlier about what those numbers were, and I'm not finding it in this text chain. But ultimately, I think at this point I've probably judged close to 300 or 400 rounds between the Yatley years, practice rounds, regional competitions, international rounds. And, my judging style is not unique to me, and it's developed from the experience I've had judging with a lot of people that have been doing this longer than me and who are smarter than I am. So these are my thoughts. You should listen to your advisors, your coaches, other people with experience. Different judges are going to look for different things, and you can get a feel for different judges by the questions they ask. The questions they ask are going to be the things that they care about. The folks that ask for the law are going to care about the law. The folks that are more concerned with, flowery speeches are going to be obvious to you after you've done a couple of rounds. So focusing on that categories, knowledge of the law is about identifying the relevant law. What law applies? What general principles? What conventions? What general principles of law? What things are going to be utilized to connect the facts of the compromise with the conclusions that you want the bench to draw. And being able to articulate and talk about and to utilize that law in a way that makes sense, that is able to be explained. Being able to state the rule that, the Geneva Convention says that conventions adopted are not retroactive unless they specifically say so, and that comes from Article 30, whatever it is kind of the norm, is kind of expected. It becomes the average. Understanding why from reading the commentary, the nuance of that, how that is and why that is, the idea of why that rule makes sense in the international order, and being able to articulate that and how it's relevant to the claim you're making is where you get a lot of the knowledge of the law. The other area where I tend to reward agents is by recognizing the limitations of their warrant and the limitations of their claim. By being able to say not every person born in Bermuda is a British citizen, but by saying, except for exceptions not applicable here, such as being denaturalized or being a foreign visitor, persons born in Bermuda are British citizens. Having that nuance and being able to articulate that nuance demonstrates a depth of knowledge of the law that gets points in rounds. The other big category is the questions and answers. The big points in questions and answers come from directly answering the question that was asked. In a lot of rounds, agents don't answer the question that was asked. And this happens for two reasons, and in most cases, they get kind of different reactions. The first is where the question's misunderstood, that a question is directed at what is the backing for your argument, what is the legal rationale or warrant for your argument, and the response goes into an analysis of the grounds and the facts. If it happens once or twice, it's just a misunderstanding, and generally there's no consequences for it. It's not going to hurt your round missing or misunderstanding one question or two. What is going to hurt your performance in a round is, instead of answering the question that's been asked, answering the question that you wish had been asked. If you get confronted with a hard question, you've got to answer the hard question. You can't just ignore it and pretend it was a different, easier question and you'll answer that one instead. That ends up being very obvious to judges, and it is something where we feel like the agents end up being evasive. Sometimes the questions don't have good answers and may not have good answers for your argument. Acknowledging the qualifications and the rebuttals and doing your best to fight back against them is more responsive and will get more points than denying a reality. About 8 years ago, and I forget all of the specifics, just the format, one of the questions presented in the compromise was an open area of the law, and both sides had very good arguments going back and forth. And then after the memorials were submitted, the ICJ came out with a decision, in a 13-2 decision, that 100% shut down the rebuttal. I mean, the respondents. The respondents completely had no arguments, And the applicants every single time got up and hammered on this decision and was like, we know the answer, it has to be this, we win, thank you very much. And the respondents would make their arguments as best they could, and the benches would always say, well, what about this decision? And the agents who came back and said, yes, the ICJ made this decision, but here's how our situation is different. Here is how that decision generally doesn't encompass the specific circumstances we're talking about with here. Yes, that decision was great, but it's not preclusive. It's not binding on what your decision is. And we think that these aspects of the law, in our case, lead to the respondent result. There was a dissent, and a lot of respondents took the arguments from that dissent and said, this is still the way the law is. Reasonable minds can disagree. And those respondents, in a lot of cases, earned a lot more points on this issue because the applicants just said, ICJ made the decision, I don't need to talk about it anymore. And the respondents were able to say, here are all the things I know about the law from all of these different places, and I'm going to put them together and synthesize them and make the best argument I'm going to have. Now, would that work in the real world? No. Your client loses. So sad. But this isn't the real world. This is Jessup, and it's how many points you can get demonstrating your knowledge of the law. So, just because the law is going to be difficult, just because a judge has hard questions, you will get more points engaging. The other aspect of question and answer is the ability to transition back into your argument. Sometimes you can do it incredibly seamlessly, but sometimes you've already moved on into the third or fourth or fifth point of your argument, and a question brings you back up to number 2. And in those circumstances, don't be afraid to rhetorically step out of point 5, answer the question, give it a beat, and pick up back where you were. You don't have to restart your argument in 2 and stay there forever. Whoa, and I'm missing questions. All right, so in I'm going to hit that one there. Okay, so how do you handle negative facts or weak points in your legal argumentation? When do you know when to concede the argument versus continuing to contest it? If you have an argument that, I think about claims as the narrowest set of circumstances in which your argument still prevails. If you have a good faith, legally supported way to articulate a way that, while in most cases you lose, but in this one specific circumstance your claim is still true, and you have time to deal with all of that nuance and all of the warrants and all of the backing, and deal with the fact that your argument is effectively a nuanced edge case, rare circumstance, you can go all in on this. In other aspects, maybe it makes sense to concede it, to say, okay, it's not worth investing my time resource into spending 5 minutes to build out this argument. Ultimately, that question comes down to one of strategy, about how important your claim is to your ultimate goal of proving that question presented number 3. If your claim is not an integral component of keeping your position together on that point of law, that question presented, it may be better to concede it in some circumstances. The details matter and the particular circumstances matter, mean, should you at the beginning of the round say, we can't win QP3, I'll concede it, and we're just going to talk about QP4? Absolutely not. But if there are three different ways that, particularly on the respondent side, where QP3 is usually respondent did very bad thing, and respondent has to argue, we did bad thing, but it's okay, and there's three reasons why it's okay. If any one of those three reasons is a lawful basis for respondent to engage in what's usually terrible conduct, and one of them is incredibly weak and is an incredibly nuanced position, and it just is not working, particularly in the oral rounds, that's a great concession to make. To say, reason number one, and it probably should be reason number three, reason number three, even if the court doesn't believe it under these circumstances, reasons number one and reasons number two are independent bases on which respondent's conduct was appropriate. Reason number three doesn't matter that much. Let's talk about the next thing. Now, you can't be that flippant about it. You have to be in the formal language of it, but that can be the goal there. Knowledge of the facts, going back to the scorecard, and I'm going to get to the other question when we get down to style and poise. For knowledge of the facts, the goal here is identification of those relevant facts, the legally significant facts, and to deploy them appropriately as grounds in support of the claim. That these grounds are the building blocks that your warrant attaches to. The legal bases are all there. For example, for there to be, a waiver of a legal right, there has to be a knowing affirmative decision. You need to provide facts of both knowing and the affirmative decision. And if you're not identifying one of the required factual components to get to a warrant, I tend to consider that a lack of knowing which facts are relevant. On the flip side, arguing about what the facts mean or trying to draw wacky inferences from the facts, I don't think that demonstrates a knowledge of the facts. There may be some reasonable inferences that can be drawn from facts under Corfu, but again, that is really about figuring out what are the relevant facts about control and the inferences and who has those responsibilities, and then using Corfu and Corfu inferences as the warrant to get to your claim that this thing is true. And so keeping the structure of what is a fact versus how those facts work is a component to the knowledge of facts. Style, poise, and demeanor is something that I have been accused of neglecting from folks, that I care less about how your argument is presented than I do about the merits of the argument. This is where there are some grounds for addressing emotional aspects. Human rights violations, violations of the rules of war, all of these things. It's a two-way street, because on the one hand, your argumentation cannot be callous and ignore the human aspect when we're dealing with human rights or international human, when we're dealing with human rights law or, individual protections under the laws of war, or, also on the environment side, when we're dealing with an environmental catastrophe, you can't ignore the aspects of tragedy that are inherent in those things. On the other hand, arguing that, respondents should be punished because, bad things happen to good people isn't a legal support for a claim. Um, and those emotional appeals are generally going to rarely be successful, particularly when they're very overt. Telling the story of the poor people that were, harmed in applicant country because of, respondents, just carpet bombing or whatever they were doing bad in this particular year is not going to have a huge impact on a bench of judges who have been dealing with this and have heard that argument a bunch of times before. The other aspect is, particularly in international law, when we're dealing with this large-scale public international law at the ICJ stage, this is an aspect of one country's rights and obligations versus another country's rights and obligations. The individuals tend not to matter at the context of evaluating countries' rights and obligations. I think those types of emotional appeals are more effective in other moot court formats. If what we were simulating in the Jessup instead of the ICJ was, the Yugoslavia Tribunal or the ICC, where we're dealing with individual criminal responsibility for crimes against humanity, those types of emotional appeals where we're dealing with an individual's rights and responsibilities with respect to another individual, those emotional things have more play. Countries don't have emotions. Countries have sovereignty, territory, a people, and one other thing under Montevideo that I cannot remember. But what they don't have is an emotional state. And so one country trying to play up an emotional state isn't particularly effective. Now, judges are people too, and the respondent can't be callous to the existence of human suffering in the compromise. So it does have to be there. My personal opinion is that being subtle, being gentle, and putting the applicant's always the one who gets to do this, but putting the respondent on a bit of a defensive, so they have to spend a little time tiptoeing around the alleged war crimes they committed in the compromise, is the way to effectively use it for an applicant. On the other hand, I am probably on the far side of not finding emotional appeals effective in these arguments. There are other judges who take a much different view of it, and so it may be a round-to-round thing about how much of the emotion into it is. But remember, this is a simulation of oral argument before the ICJ. It is not theater and dramatics. The other thing in the style and poise and demeanor thing that I think sometimes gets lost is that, particularly the judges that I know, we do this because the argumentation is fun, that we enjoy engaging in the legal debate and exchange of ideas and how things fit together, and that engaging in that debate is going to get points for style and demeanor. Being willing to engage the bench, being willing to have the discussion back and forth, I think is really effective. It also is really effective in giving you the opportunity to collect all of those law points from the other 75%. And so I would encourage folks to engage, to be responsive, and to play the game and get into the debate. Most of the judges are not going to be offended when you disagree with them. And in a lot of cases, what the questions are doing is setting up the opposition argument, because I want to hear a direct rebuttal or argument against it. And for the applicant, it may be what we anticipate the respondent saying. It may be something I've been thinking about because I've heard this applicant argument 10 times, 15 times, 20 times. 2 years ago at internationals, I judged 10 10 rounds, prelim and out rounds at one U.S. national, did the other U.S. national, I think did 11 rounds, and then did 13 or 14 rounds at the international. By the time you've done 30 plus rounds from 30 different applicants, you've heard the same argument 30 different times. And you have thoughts of like, how does this work? Let's play with this idea. And being willing to engage in that is going to get a lot of points there. And if we get to the bottom of it, that's fine. The last component in the oral rounds is organization and time, which is, does your argument make logical sense? Are you putting these pieces together in a way that lets me know where you're at in the argument, what you're trying to prove, and are you keeping your eyes on the time? The big thing for oral rounds that I want to impress on everybody is the bench is not your enemy. Our job is to find how many points we can pull out from you in our questions, because anyone can get up and memorize a 20-minute speech and say things about the law. That doesn't allow us to evaluate your knowledge of the law, your ability to answer questions, your knowledge of the legally relevant facts. Only through the give and take of the questions are we able to evaluate that. And we, in a lot of cases, are going to ask questions until we've exhausted your knowledge. When you run out of answers, I don't know can be the answer, and that's fine. It doesn't mean you've lost the round because you didn't know the answer to one question. It just means we've gone off on this tangent to the depth of your knowledge. Let's find a new place to explore and find points. So that's the takeaway for oral rounds I like to impress on folks. But before we get to the oral rounds, you've got to get through your memorial writing. And that is happening now, and those are going to be due soon. So the memorial score sheet. You have 5 categories, each of which is worth 20 points. So, knowledge of law and facts. This is the things that we talk about with knowledge of the law and what are what are the legally significant facts and how do those things come together? What I look for in grading memorials is that people are making clear and articulate statements of the law and then relating them to the claims that they're making. You know, applicant did thing lawfully. You know, here is the law, here are the facts, here's how they relate. Our conclusion is true, our claim is true. That also extends into the proper and articulate analysis. This is putting all of those things together, the relationships that you've selected the applicable law, you've selected the applicable facts, and you've put them together in a way that makes sense. The extent and use of research is how you have deployed the research that you've done. What this category is not is a question of how many different books you have cited. The extent and use of research is about, have you found the applicable law and facts, and have you gone in depth with respect to the analysis, the use of what you have found. Between 2 memorials, A memorial that has 10 different random statements quoted from 10 different random books is going to score worse than a memorial that engages in a deliberate and in-depth analysis of a convention, its preparatory materials, its commentary that goes into depth with that source rather than just shotgunning a bunch of different sources at me in the memorial. Clarity and organization, to me, are about the logical structure of the argument, and that the points that you are making in the arguments are leading to and are correct expressions of all of these components. Clarity and organization is that the argument structure and the way you're presenting it makes sense, and that it answers the question that's being presented. It's less about flourishes in language. Simple, direct language is fine. Where I like to see nuance and big fancy words in the memorial is where those are being used to qualify claims, to narrow exactly what you are saying to be applicable to your situation, and then to be able to say these counter arguments are not applicable. And then style, formatting, grammar, citation. These are the structural elements of good writing. It is a little bit of all of the components, but it's really about, is it comprehensible? Is it readable? So going into that, knowledge of facts, again, my personal view on memorials, I think I'm up to about 200 or 250 of them at this point. What I'm looking for is your memorial talking about the relevant facts? In the facts section, do I have a clear understanding of the legally significant components that you're going to be analyzing in the body of the memorial? And then the law. What law applies here? And are we using that to make the relationship to say, applicant wins QP1? The analysis is about situating that law in its context, with the backing, where it came from, with the qualifiers, when it doesn't apply, and addressing the likely rebuttal arguments. Very effective memorials are going to address the counter argument. They're just not simply going to pretend it doesn't exist. If you have if you have an open area of the law and there are two things, your argument is going to be legal idea 1 is correct. And then the rebuttal is, legal idea 2 is sometimes applied in this situation, but it's wrong for reasons 1, 2, and 3, or it doesn't apply here by its own terms because of these reasons. You want to anticipate opposing arguments, both on the applicant side and on the respondent side, to get to demonstrate your depth of knowledge of the law and how it addresses other legal issues. Extent and use of research, I think I mentioned, this is, the depth of your analysis in that research. It's not how many different sources can I find to say a thing. It's about using the sources you have the best. American teams from the United States tend to do a very broad spectrum, and the law schools in the United States tend to have, let me find 10 different people saying the same thing. And I find those as being less scored and more harshly scored than teams I get, and some of the best memorials I've read have been out of places that were only citing the batch materials. That the batch materials were, this is the world we're working from, there's some other sources brought in to expand on some nuances, but it's really about the depth going into the batch rather than spending the time to find and grab things from left, right, and center to bring it in together. And I say law schools from the United States because for the regional rounds, I have to grade a lot of those memorials, and they have a much different feel than memorials from the international community. Clarity in organization, directness, precision, coherent flow of the argument, they make sense. And then, where these arguments come from is the citation. How readable is it? Is it comprehensible? In the memorial, being direct is a really appropriate way to do this. And readability is a big thing. The last kind of point on memorial is that there are a lot of different styles of legal writing. Common law legal systems like the United States, like Great Britain, Australia, New Zealand, tend to write in a different way than students from legal traditions that are what's sometimes called Roman law or code-based law. The common law folks tend to write conclusion, claim, the legal rule, the warrant, then the grounds where those come from, and then the applying that legal rule to those grounds. Code-based legal systems tend to say the factual background, and then the legal rule, the grounds, the warrant, and then have the claim at the bottom. And when the memorials are being judged, they are being judged by judges from both common law and Roman or code-based legal systems. For that reason, you may want to consider being aware of those different styles of legal writing and bookending your argument by both starting with your claim and your conclusion, and concluding with therefore claim, so that the common law practitioners, which at some level tend to be a little overrepresented in judging because of the number of judges from the United States and from England, and English speaking judges from Europe versus the code-based legal system. Bookending it that way may be of assistance to fit it into what judges are looking for in the memorials. And so that formatting and organizational technique may be useful because there are differences in how those legal traditions work. That's the oral rounds, that's the memorial rounds, and that's how I personally think about argumentation. Can you rotely apply the Tolman model? No. But if you understand how these pieces fit together, that your claim is what you want the judges to adopt, the warrant is the legal rationale, the grounds are the factual things, and how the claim leads those grounds to your claim, that can help you make more structured, tighter arguments that take fewer words and allow you to make more arguments in your word-constrained memorial, and can help you make more focused arguments to make you have more persuasive arguments in the oral rounds, and hopefully also help you understand what part of your argument is a judge's question directed to, so that you can give more direct, more responsive, and feel better about your ability to respond to questions. And hopefully that will help you score more points, because as much as we all love this game that is Jessup and the legal training that it provides, your job is to get points. And so whatever you can do to get those points is what you should be doing. If there's any other questions, let's get them in the chat. Otherwise, I know it's getting late here for me in the West Coast. I know a lot of you, or it's even later, and I appreciate all of your times tonight and your commitment to the Jessup and to the global legal community.